Hello, I'm Jennifer Blue Rosman, Chief Human Resources Officer of Chrysalis Health. I'm here today with Eduarda Lacasa, our Chief Operating Officer and in-house legal counsel.
If you're new to Chrysalis, I'd like to welcome you to our company. And if you've been with us for some time, I'd like to thank you.
To talk to you today about HIPAA violations, confidentiality, and personal health information of our clients and families. As you know, in our industry, this is crucial for us to protect and maintain for the well-being of all of our clients as we're providing service provision.
One of my main duties here at Chrysalis is to oversee risk management. And in that effort, we have a corporate compliance program which you must be aware of. There are several measures that we encourage you to take to support your service provision should it ever come into question. These include sign-in logs at any school or facility that you attend that has such a sign-in log at the reception. Even if they allow you to come in without signing it, you should insist to sign it yourself. We also have our own form for sign-in for a client or guardian at the time of service delivery. We highly encourage you to use them. Chrysalis Health is committed to preventing fraud and abuse in regards to the healthcare programs that we deliver. And to that end, we have a comprehensive corporate compliance program which includes training our employees in regards to appropriate practices related to our documentation and billing. It also covers identifying fraudulent activity and how to correct such activity. We are governed by federal and state law with regards to false claims. Now, you should be aware of federal and Florida governing laws with regards to the filing of false claims or fraudulent claims. Any person who knowingly presents a false or fraudulent claim or knowingly uses or causes to be made a false record in support of that claim or conspires to do any of these things is subject to the federal and Florida false claims penalties. These penalties are severe and include fines of between $5,000 and $10,000 plus 3 times the amount of any damages to the government. These penalties for violations of the federal and Florida False Claim Act include loss or suspension of your license. This loss or suspension is reported to existing or future employers. And of course, the most severe penalty is incarceration. The term knowing or knowingly includes actual knowledge of any information that is false or fraudulent in support of that claim, or deliberate ignorance or reckless disregard for the truth of the claims that are being made. Chrysalis Health is a mandated reporter. Your supervisors and officers of the company, myself included, are mandated to report any knowledge or reasonable suspicion of a false claim being made. In Florida, the Medicaid Fraud Control Unit oversees and investigates potential fraud. There's a hotline for reporting. If you, as an employee of Chrysalis, become aware of any fraud committed by someone in this company or in any other company, we are mandated to report this. Florida also has additional Medicaid provider fraud statutes which include anti-kickbacks. If one is referring a client for a service that's paid for by Medicaid and receives anything of value, not just monetary, for making that referral, you are subject to the anti-kickback statute and can receive significant penalties for such violation. This is a third-degree felony. Incentivized to report these claims as well. These are called key tam cases. Anyone who has, or otherwise known as a whistleblower case. Anyone who has knowledge and reports such knowledge that results in an action against you is incentivized with a percentage of the recovery. This means that a client's guardian, or anyone else working in the field that becomes aware of any information which would lead to a false claim prosecution will receive a percentage of any recovery. I want to know that it's not just us watching.
Right.
Other people have an incentive to do it. Chrysalis Health supervisors conduct regular quality assurance and satisfaction surveys by contacting the clients or their guardians to inquire as to the services being delivered. These sometimes result in identifying discrepancies with regards to the service delivery. This will prompt us to make further inquiries by contacting an entire caseload and verifying the service delivery on the dates and times that they're being reported. In the event that we uncover such discrepancies, we'll ask you to come in, we will interview you. If we're unable to verify at that time the claims that are being made, we are mandated to report this to the Medicaid Fraud Investigation Unit. From that point on, they will undertake the continued investigation of the matter. During the course of the investigation by the Medicaid Fraud Investigation Unit, Chrysalis Health is compelled to suspend you without pay during that period of time. In the event that there's a finding of false claim, you will be terminated from employment.
So we're here today to speak with Eddie and ask him a couple of questions related to HIPAA.
Well, the most important thing that you must know about HIPAA, which is also known as the privacy rule, is what disclosures you can make that are permitted. Disclosures are permitted without consent of the patient. For the delivery of service or treatment, for billing purposes, or in the event of a potential for harm that is imminent to the client, you may disclose protected health information. Otherwise, we're going to need a signed consent for the disclosure of any protected health information. We have a variety of agreements called business associate agreements with other providers that we work with in the treatment of that client. Those other providers we are permitted to give disclosure of protected health information to. Law enforcement is also a permitted disclosure. In the event that you understand or you believe that a client is in danger of imminent harm or has been harmed in the case of sexual abuse on a child or a vulnerable adult, or if a law enforcement officer requests the information from you, you are permitted to make such a disclosure of protected health information. If ever in doubt, speak to your supervisor or contact me directly and I'll help to guide you.
In regards to consent forms, when we have an employee that's going out and working with a family, and let's say they're in the home, what's the protocol in terms of having consents for everyone that you speak to within that family unit for that client?
Well, one of the most important things about consents is to make sure that the right person is giving it. In many instances, someone may think that they have the legal capacity to consent just because the minor client happens to be living with them or staying with them at the time. Unless it's a parent whose rights are intact, or there's a court order which otherwise allows someone who's not a parent to sign a consent, you must make sure. You can also check with me or check with your supervisor to make sure that the consent that you have obtained a signature for is from the correct person.
And with that being said, the services that we provide in our outpatient department are individual therapy services. Our outpatient department does not provide group. So for instance, when a therapist or a case manager, let's say, is going into a school and maybe they have multiple clients in that school as students, is it permissible to provide group therapy sessions to all of those clients?
At Chrysalis Health, we only do group therapy in our psychosocial rehabilitation program. Other than that, in outpatient programs, we do not do group therapy.
For instance, going into the school, if you have, for instance, 4 clients that you service that are all Chrysalis Health clients, you have to see each client individually for that individual therapy session, and the service provision is documented in your progress note separately for each individual session. That does not mean that you can take all 4 of those clients, have a group session, and then provide the progress note for each hour for that particular client. So Eddie, in regards to other types of HIPAA violations, what are some examples that you can provide that may seem benign at the time that employee is partaking in that situation, but in actuality is quite illegal?
There are many things that can happen with regards to HIPAA that can result in an actual violation. You know it when you see it. First and foremost is anyone who's not authorized to view or obtain that information. If it's disclosed to them, it results in a HIPAA violation. It could be as simple as taking a photograph with information that can be seen in the foreground or the background, leaving your laptop in a vehicle or another place where the laptop is stolen. Now, we take measures to secure the information that's contained in the laptop, but nonetheless, it can be a violation of HIPAA if that laptop is stolen and someone is able to obtain the information out of there. Disposing of notes or other records that have information that are not shredded or otherwise disposed of properly. You can't simply toss the information into a garbage can and expect that it's protected. Use your best judgment in these cases with regards to what information can be disclosed to someone who's not authorized to have it in the way you treat such information.
Going back to the laptop in a vehicle, what would be a consequence of someone saying, you know what, I'm going to the grocery store, I'm just running in for 10 minutes, I'm going to put my laptop in the trunk of my car, they come out, the laptop is stolen.
We emphasize this because it happens. It happens far too frequently. Laptops that are in view of someone passing by your car are susceptible to being stolen. The information that's contained therein is HIPAA protected information. You must report immediately the theft of any information taken from you or if your laptop is stolen so that we can take the adequate measures to secure that information. Of course, if you fail to follow the protocols of Chrysalis, you're subject to suspension or even termination, and we will ask that you reimburse the company for the loss of the laptop.
In addition to paying back the loss of the laptop, which I believe is $500 for the laptop, you will also be written up as a policy violation. So there will be consequences with that. Second offenses will result in termination of employment.
And the company has to undertake a significant amount of measures to notify the individuals whose information is contained on them. We have to notify them in writing that their information, including social security numbers or other identifying information, may have been lost.
So Eddie, talk to us about professional boundaries in the client's therapist or case manager relationship, and what are some areas that we should be sure not to cross to safeguard ourselves?
Well, there's a lot of boundaries that you should be aware of and should avoid crossing. We've had instances where a personal relationship has developed that's outside the boundary of what's otherwise professional. In instances that I'm aware of, cases where a therapist has rented an apartment to a client or their parent, and that can result in a non-payment of rent, which can result in litigation, which could put the therapist in a very tenuous position with regards to that professional relationship. Of course, any personal social relationships must be avoided. The lending of money must be avoided. Even doing things which you might otherwise think are just being nice or helpful can go too far and cross those boundaries. For example, taking care of a pet while a client is on vacation could have very negative ramifications and can cross those boundaries. Be aware of what the professional boundaries require you to maintain. Assisting clients not just while on vacation or can include when they're in crisis, if they've been Baker acted and ask you to take care of their home or their pets. You must be aware that this can result in crossing the boundaries of what's otherwise permitted. Use your best judgment. When in doubt, contact your supervisor or contact me, and I will help you, guide you through what's appropriate.
There are some other situations, Eddie, where life is very busy and complicated, and some of us have children, some of us may have other situations that come up with a friend or family member, and yet we have sessions scheduled and we want to kind of keep about the day and make sure we follow through with what our clients need. Talk to us a little bit about those types of situations and bringing visitors or family members to a session.
You should not bring anyone with you to one of your client appointments. Even if you're going to the client's home and leaving your friend or relative in the vehicle, you've exposed that person to the address of a client. That in and of itself is a violation of HIPAA. When going to a client appointment, you should go by yourself or with another authorized person who has obtained the same level of consent.
So Eddie, talk to us a little bit also about transporting clients and what the ramifications could be there.
We have a policy against transporting clients unless you're a case manager or it's an emergency situation. There's an important reason for this, is because there are a lot of negative things that can happen during the course of a transportation. Of course, you could be involved in an accident that results in injuries to yourself or the client, and that could have very negative liability for the company. Aside from that, you can expose yourself to being alone with a client in a situation that's not otherwise intended as part of the delivery of our service. So, in short, do not transport a client unless you're a case manager and it's an emergency.
Eddie, tell us a little bit about what should happen if a case manager or a therapist receives a subpoena regarding one of their clients that they serve.
When you receive a subpoena, you should consult with the medical records custodian, who will help guide you through responding to the subpoena. The subpoena could include testimony in court or in deposition, and the production of records, which will be through the medical records department. We will help coordinate the time that you go and attend the trial or the court case so as to fit within your schedule. We'll try to accommodate it as much as possible. Do not ever appear in court or give testimony without being subpoenaed and with consulting with the medical records department. Always remember that your supervisors, officers, and directors of Chrysalis, we're here to help and guide you through your delivery of services at Chrysalis Health. If you ever have any questions, please do not hesitate to ask. Thank you.
And thank you once again for everything that you do for Chrysalis Health. Together we make a team, one mission, one team. Thank you.
Hi everyone, I'm Dr. Sheila Rappa. I'm the Chief Clinical Officer of Chrysalis Health. I have been at Chrysalis for about 20 years, and believe me, I have seen it all clinically. So what I want to do is just take a few minutes and explain to you the best ways to handle it when a client is in crisis. It can be suicide, it can be homicide, it could be substance use. There's many ways that our clients can go into crisis, and we need to be able to think on our feet, and we need to be able to handle these situations and handle them appropriately. So I wish I could sit in trainings and meet every one of you, and the ones that I already know, I wish you were here with me, but we're gonna have to do it this way. But you do know that if you have any questions ever about safety issues or what to do if you have a client that is in crisis, that I'm only a phone call away or an email away. And you also have your supervisors available. So let's talk about suicidality first. What do we do when a client is suicidal? Many times I hear a therapist say, my client says all the time, I don't want to live, I don't want to be here, and I really just think it's attention seeking. We need to remember that even people that are seeking attention sometimes kill themselves. You know, we have to take it seriously when somebody says that they're suicidal, that they're having thoughts of suicide, even if they have never acted on that in the past. Some of the things I want you to look for if you're with a client and you think that they might be suicidal are suicidal ideations. Are they saying things like, the world would be better off without me, or I just don't even want to be here anymore? While these aren't overt suicide statements, they are statements that lead us to believe someone's thinking about committing suicide, and we have to be alert to that. One of the things that goes along with suicide, when we think of evidence-based treatment and we think of what we have seen in the research that goes along with suicide, what we see are people that have co-occurring disorders are more likely to commit suicide. So are you sitting with a client that has a co-occurring disorder, meaning they have a psychological disorder, but maybe they also have a substance use issue? Or maybe they have two psychological disorders. So someone with more than one psychological disorder is going to be more at risk for suicide. Another thing is if it's someone who has recurrent depressive episodes. You've seen this client, and this client climbs in and out of depression or kind of stays in a depressive state. Sometimes what we think as clinicians is they're starting to feel a little better. I start to see my client climbing out of depression. This is the time to watch closely for suicide. When people are in a very low point in their depression, they normally don't have the energy to commit suicide. But as they start to climb out of that depression and their energy level increases, that is when they can become more active with suicide. So you have to keep your eyes open for that. Do they have previous hospitalizations? Do they have previous suicide attempts? All these things have to be found out by what? By talking, right? You have to sit, you have to talk with your clients, and you have to get on subjects that are uncomfortable at times. But what you're going to ask them is, have you had suicide attempts before? And if they say yes, then we want to know, how have you tried? What have you done? And are you making plans now? These are important questions that we need to ask just to make sure that our client is safe in the moment. If they know other people that have committed suicide, this is very common in adolescence. So knowing when your client comes and says, one of my friends committed suicide, that puts your client at higher risk for suicidal behavior. So keep your eyes open, keep your ears open if they're talking about friends or loved ones that have committed suicide. Also, if you have a client in front of you that has recently had a huge loss, it can be an economic loss, it can be an emotional loss, it can be a family loss. Loss issues many times drive people to thinking that they don't want to live anymore. So again, keep your ears open if your client is talking about loss issues. Age is also correlated with suicide. Between 15 and 24 are the ages that we see a lot of suicide attempts, and people that are age 50 and over. That doesn't mean if your client doesn't fall into one of these ages that you look the other way if they say that they're suicidal. But we do know that these are more likely ages for people to be depressed and to want to end their lives. If somebody is experiencing a disability and can't get out of their house, or something has changed in their life medically, these are people that are at risk for suicide. And people that are very isolated. People that think that there's a stigma when they go to a psychologist or psychiatrist or see a therapist. People like this are more likely to be at risk for suicide. So what do you have to do as the clinician? First of all, you're going to talk to your client, right? You're going to do a thorough interview. You're not just going to ask simple questions. You're going to get to the heart of what's going on with your client. You need to be able to recognize the risk. And not only just recognize the risk, you want to detect it and know how at risk that client is. When you are thoroughly interviewing, it means you are asking questions about your questions. And what I mean is, it's not enough to say, hey, how often are you feeling this way? What I also want to hear you do is, how often are you feeling this way? Can you tell me how many times last week? Can you tell me what days? Can you tell me what time of day? Can you tell me the exact thoughts that went through your head? As you start to narrow down the thought pattern and then the intent, and then to see if they are overtly suicidal, you're going to be able to put them in a risk category. You're going to be able to figure out how risky this client is and what do I have to do? How is it different to handle a client who's merely talking about it, doesn't have a history of it, and probably will never attempt suicide? What do I do for that client as opposed to what do I do for the client that's saying, right now, I am not safe, I have a gun in my room and I'm going to use it. How do we handle this differently clinically? And we're going to talk about that in a minute, because one of the things you want to do is determine that level of imminent risk. You also want to develop a plan for that client, and you want to document. It doesn't matter at all if you go every single week and you tell your client, are you suicidal, what's going on with you, and you get an answer from your client and you feel like your client is fine. If it is not documented, it did not happen. So just remember that if the worst happens and something happens to your client, whether they commit a homicide or whether it's suicide or whether they're violent against themselves, if I go back to your chart and I don't see that you have been checking in with them and asking them about these thoughts, it's as if it never happened. That not only is tragedy for your client, it also puts you at risk. It puts your license at risk, and it also puts your supervisor's license at risk. So I'm begging you, document, document, document. And if you have any questions about documentation, that's what your supervisor is about. So you go to your supervisor and you find out. Let's talk about the levels of risk really quick, and what you should do in the different levels of risk. let's say your client comes back at low risk, is a client that kind of says, I just don't want to be here anymore. Listen, I have a teenage daughter, so my teenage daughter's favorite thing is, I don't even want to live. My life is worthless. She's never going to commit suicide. She's never going to think about it. She's not depressed. She's a teenager being dramatic, right? But still, we're going to listen to that, and we're going to classify her probably as low risk because she doesn't have any other risk factors going on, and she seems to be fine. But even with someone that's low risk, we have to give support, we have to listen to them, and we have to make a note in the chart that the client has said this, but we have reviewed all the aspects of suicidality, and it doesn't look like there's anything that is going to happen at this time. We might have someone that's kind of in a medium state. This is a person that maybe has fleeting thoughts of suicide and has thought of a plan. Maybe the plan isn't very realistic. Maybe the plan is, I'm going to jump off the Golden Gate Bridge, and they live in Florida. This is still something that we have to take seriously because this is someone that not only says that they want to die, but they're thinking of ways that they could die. So this is someone who has medium or moderate risk, and we really want to staff that with our supervisor. Really, anytime anyone makes a statement that seems like they're suicidal or homicidal, you want to staff it with your supervisor. Make sure that they're aware of it, and not only just staff it and make sure that they're aware, you're going to do a progress note, and you're going to let whoever reads your chart know that you realize that this could have been something serious, and you went to your supervisor immediately about it. If someone's at a moderate risk, again, you're going to go to a more experienced clinician. That might be your supervisor. That might be another supervisor that's around. If you can't find your supervisor, never think, oh, I think I'll just wait until the next staffing to handle this. Don't wait. Pick up the phone, call your supervisor, and if you can't get a hold of your supervisor, we have a ton of other directors and supervisors here, including myself, and we can all help you. You're going to make sure that the client support system knows that they are feeling suicidal or that they're having suicidal thoughts. Support is huge in people that are suicidal or even homicidal. So what you want to do is get to that support system, let them know something's going on. And you're going to start really making a solid safety plan and a solid crisis plan. These are plans you've probably seen if you work here. If you have never seen them because you're new, you're about to see them. So you will get very familiar with our crisis plans and our safety plans. Also, make sure that if the client has any access to things that could end their life, if there's a gun in the house, if they're saying they want to stab themselves and we know that they have sharps in the house, this is where that family support comes in and where we get things that could be lethal out of the hands of someone who could be suicidal. And we're also going to up how many times we're seeing them in therapy. And we're going to be checking on them frequently and making sure family members are also checking on them and reporting to us. This isn't the time to get so involved in your work and so involved in your other clients that this one kind of falls by the wayside. This is the client that has to be first on your priority list and first on your supervisor's priority list, because a moderate level of suicidality or homicidality is something we absolutely have to take seriously. Finally, let's say you have a client that is severe, is at high risk. This is a client that tells you, I don't want to live anymore and I'm ending it today. I've been thinking about getting in my car and just driving into the ocean. I feel like I wish I was hit by a bus. And they're thinking not only of dying, they're thinking of ways. They're thinking of who they might write a note to, or they're thinking of when would be most convenient for them to do it when no one's home. These are people that are in severe crisis, and they have to be either admitted into a psychiatric hospital voluntarily, where the family would bring them and sign them in, or they bring themselves, or involuntarily, where we would initiate a Baker Act for them. Never, never, never initiate a Baker Act or initiate a voluntary hospitalization without letting your supervisor know. And again, there might be times you can't reach your supervisor. Nobody's available 24/7. Get another supervisor on the phone. We have a list at Chrysalis, and it's a tree that tells you all the supervisors all the way up to coming to me. And whatever you have to do, you make sure that you get somebody on the phone and that you realize that you're initiating a Baker Act and you're taking away someone's civil liberties. So we have to take it very seriously, but we have to keep that client safe. When you're talking to somebody that's suicidal or homicidal, remember, you're not just asking them intent, you're asking them if they're planning, how they're planning it, do they have an access to means to kill themselves? We're not stopping there, we're asking them their protective factors. Who are the people in their family or who around them can help keep them safe? We're also trying to find out about their past experiences. Have they done this before and how many times? And have they thought about this before? How far have they gotten in the process? And an important part of when you're assessing for suicide or homicidality are their future expectations. Normally, when people are suicidal or even homicidal, they don't really see a future for themselves. So they sense that they won't live long, or they sense they have no hope. When you hear this from somebody, you kind of realize this is something that puts us into a more high risk situation for suicide and homicide. So we always are going to ask about those future goals or where they see themselves in their future. Remember, in terms of homicidality, that we have a duty to warn. We are in a state where we have a duty to warn if our client tells us they're going to kill somebody or wants to kill somebody, and you really believe this threat to be credible. It's not the teenager that's sitting in front of you that says, oh my gosh, sometimes I just want to kill my mom. That's not what I'm talking about. Somebody that really has homicidal tendency and that has been thinking of ways that they could kill someone, then we have a duty to warn. Our duty to warn means we have to try and get in touch with that person. If we cannot get in touch with that person, it has to be reported to the police. If we can get in touch with that person, we still should take the second step and report it to the police. And all of these things are, again, they go through the supervisor and then they're documented in your progress note. I can't really stress enough how important it is that you are going through your supervisor for all of these things, because they not only are horrible things that could happen to our clients, they also put you at risk as the clinician and the company. So you have to be very careful how you handle this. And the most important thing to remember is your documentation. That whatever you're doing on behalf of that client, you are documenting and making sure everybody knows that you've followed every single step. I'm going to end with just a quick story. We did have a client that unfortunately killed themselves, and this was a while back, and I was asked to look over the chart. And the therapist that had the chart had done everything perfectly. I don't see that often, so that's why I'm going to tell you guys what I saw in the chart that I loved. The therapist realized that the child, it was a teenager, that the teenager had depression. She realized that this child with depression had attempted suicide on other occasions. She initiated Baker Acts for this adolescent on 3 different occasions. She asked the mom to sign a safety plan and to help keep the child safe. And in the end, it was really the home support and what happened in the home that kind of precipitated the child killing herself. But in terms of how we handled it, we made a referral to psychiatry. We kept in touch with the psychiatrist. The supervisor was involved. We worked as a team with this client. So the tragedy happened, and there was nothing that we could have done, no more that we could have done to make sure that it didn't. But when our charts were pulled, we could tell that the therapist had cared about this client and had really gone the extra mile to make sure that the client would be safe. That's what we want to see. I just want to remind you that if something happens to your client, if they're self-interest, if they're suicidal, if they are violent towards other people or homicidal, these are the charts that are really reviewed, because, you know, we live in a very litigious world where people want to say the therapist did not do a good job, the supervisor did not do a good job, and that's what caused this to happen. You want to make sure you are covering all your bases and doing every single thing you need to do to make sure that your client and society is safe when you're out there on the job. All right, let's talk for a few minutes about reporting abuse and neglect. You know that in Florida that all of us are mandated reporters. Everybody, even people in the community, are mandated reporters, but us more so, because we carry the responsibility of protecting our client and keeping them safe. So let's talk just for a minute about what things are reportable and when do you report and how do you report. There are some people that come out of school and they don't even know who to call. They know that abuse might be happening, but they don't even know how to report it. So let's talk about all of that. First of all, as mandated reporters, we do have to report if a child or an elderly person is being abused sexually, physically, or neglected. We do not have to be investigators. It's not our job. All we have to do is report so that a proper investigation can happen. Never tell a client, well, let me wait and see if you can do better as a parent, since now you're starting some parenting issues. Or let me see, who the perpetrator is denying the sexual abuse, so I don't even think it's something that's reportable. It doesn't seem right. All of these things are not for us to decide. We are not the investigators in these cases, but we are responsible for making sure that an investigator puts eyes on these cases. So when we hear a child say that they are being physically abused, and in Florida, they can be spanked with someone's hand, but that hand cannot leave a mark or a bruise. So if you're seeing marks or bruises, or you're hearing that children are getting disciplined with something other than someone's hand, that is reportable. If a child tells you that they have been exposed to pornography before it's developmentally appropriate, at a young age, that is reportable. If a child is exposed to adult sexual activity in their home, that is reportable as sexual abuse. And of course, if a child tells you they are being touched by anyone, or if that person is wanting them to touch them, then that is reportable. Child on child. Two children having sex with each other or performing sexual acts on each other, that is reportable. Even if you as a clinician say, oh, it was just two kids in a bathtub, they were just messing around, that is, again, not for you to decide. We have to report it, have it be investigated, and then if it's unfounded and there's no problem, the case is simply closed and the people and we move on. But if we don't report and there is abuse happening in that home, then it comes back to us that we didn't take the proper responsibility for that. When you go to report, there's a few steps that you're going to have to take when you report. Some people choose to tell their client that they are reporting. Some people do not tell their client. You have to know clinically which one is best for you to do, and the way you will know that is by taking this case to your supervisor and you and the supervisor figuring out the best way. If you want, the parent can be in when you report. You call the 1-800-96-ABUSE line. That's our hotline for sexual abuse. And you will get somebody on the phone that will give you the number of the case, tell you their number, and they will advise you if it's a call that they will take or not. There have been times I have called the abuse hotline when something that I thought was alleged abuse, and the abuse hotline have said, that's not a case we're going to take. I don't normally just let that be. If I am feeling like that child's at a threat, then I will ask to speak to that person's supervisor until that report is taken. So you don't just have to say to yourself, oh, they wouldn't take the case, so make sure that you're talking to a supervisor there. Make sure that at least the phone call is being recorded, that you are telling you think that this is a child or an elderly person in danger or of abuse or risk of abuse. Once you call for a child-on-child sexual abuse case, after they take your information in the abuse hotline, they will also then patch you through to the city police, whatever city that crime occurred in, and you will have to talk to a police officer. So don't let that freak you out. That's a normal procedure in all of the counties. And then what they'll do is normally send someone from the sexual crime victim unit out with the ChildNet or DCF worker to interview the family and the child. Other than that, make sure that you're documenting in your note who you spoke to on the abuse hotline. And again, they always give you their number. Put their number in the notes so we know the name and the number of the person that you spoke to, when you called, and that you did notify your supervisor and that your supervisor was aware. Anyway, that's what we're here for. We're here to help you and support you. So any questions that you have, I'm so happy to answer them. I'm so happy to staff cases with you, point you in the right direction. And thank you for listening to me. Any questions, you can get my cell phone and you can call me or email me anytime.